evening, everyone. Welcome to the Zoning Board of Adjustment, Township of Old Bridge, March 5, 2020. Adequate notice of this meeting of the Old Bridge Township Zoning Board of Adjustment has been provided in accordance with the Open Public Meetings Act at least 48 hours prior to the commencement of this meeting by primarily posting in the municipal complex an announcement giving the time, the date, the location, and the agenda of this meeting. Also by mailing such announcement to the Home News and Tribune. Finally, by filing a copy of such announcement with the municipal clerk. Ms. Silverman, could we have a roll call?
Mr. Dewhurst?
Here.
Ms. Chevalier?
Here.
Mr. Connor?
Here.
Ms. Kidlow?
Here.
Gagnon?
Here.
Mr. Walker?
Here.
Mr. Psychowski?
Here.
Mr. Stone?
Present.
Chairman Sullivan?
Here.
Mr. Sacks?
Here.
Mr. Watt? Here. Mr. Hart? Here. Mr. Lavallo?
Here.
Ms. Drum? Here.
For those following the agenda tonight, item number 5 is a discussion item, the 2019 annual report. Board members will hold that to the end of the meeting after we get through the applications. Under the applications, they'll be slightly out of order. Number 1 is going to be Metro Storage. Number 2 is 69 Ravine. And the final one of the evening will be Jersey 34 Associates. I would ask everyone, please, here in the chambers tonight, silence your cell phone if you haven't done so already, so we don't interrupt any of the testimony, so the stenographer doesn't become confused, and it's also recorded. And for those watching at home, for those here in the chamber as well, this is being televised on cable TV channel 15, the local Old Bridge station. As such, the curfew is 10 p.m. for the television. If you're watching at home, I don't anticipate we'll be here that late tonight, but we may. And if so, we do have to shut that down at 10 o'clock. I'll try to give you advance warning of it, but sometimes we're in the middle of an application and we cannot. So the TV will go off at 10 p.m. Once again, I said something about the cell phones, correct? We'll move forward then. Item number 2 is minutes, board members. We have 2. We'll take them individually. February 6, 2020. Hopefully everyone has had a chance to read the minutes. Absent any commentary, suggestions for additions or deletions, I'd ask someone to move them into the record.
Motion.
Is there a second?
Second.
Moved in second as to February 6th minutes. Roll call, please.
Mr. Dewhurst?
Yes.
Ms. Chevalier?
Yes.
Mr. Connor?
Yes.
Ms. Kidlow?
Yes.
Mr. Gagnon? Yes. Mr. Walker?
Yes.
Chairman Sullivan?
Yes. Board members, the same applies to February 2020. Absent any commentary or additions for suggestions for additions or deletions, I'd ask someone to move it into the record.
I'll move it.
Is there a second?
Second.
Moved in second. Roll call, please.
Mr. Dewhurst?
Yes.
Ms. Chevalier?
Yes.
Mr. Connor?
Yes.
Ms. Kidlow?
Yes.
Connor?
Yes.
Chairman Sullivan?
Yes. Board members, item number 3 is appointments. As you recall, there was a temporary appointment due to paper filing, I think. Is that the reason when we did it in January? There was a short...
It was a 60-day.
Yeah, okay, well, in any event, board members, as you may recall, we did appoint Chestnut Arboricultural Forestry Professional Services for 2020. This is going to make the appointment for the entire year. I would suggest I nominate them as to do that to provide that service, consulting service for the year. I'd ask for a second.
Second.
All in favor? I'm sorry, we would take a roll call on that. Yeah.
That would have been different.
Yeah, that would have been different.
Mr. Dewhurst?
Yes.
Ms. Chevalier? Yes. Mr. Connor?
Yes.
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 Chairman Sullivan?
Yes. Secondly, it would be CME Associates, as a second consultant, CME Associates Arboricultural and Forestry Professional Services for 2020. I nominate them. Is there a second?
Second.
Roll call, please.
Mr. Dewhurst?
Yes.
Ms. Chevalier?
Yes.
Mr. Connor?
Yes.
Yes.
Mr. Gagnon?
Yes. Yes.
Chairman Sullivan?
Yes. We'll move on to resolutions for both. We'll take them individually. Resolution for Chestnut Arboricultural Forestry Professional Services 2020. Someone in favor of moving the resolution?
Motion.
Is there a second?
Second.
Roll call, please.
Mr. Dewhurst?
Yes.
Ms. Chevalier?
Yes.
Mr. Connor?
Yes.
Yes.
Gagnon? Yes. Mr. Walker?
Yes.
Chairman Sullivan?
Yes. Board members, I'll also move a resolution here for CME Associates Arboricultural and Forestry Professional Services for 2020. Is there a second?
Second.
Roll call, please.
Mr. Dewar?
Yes.
Ms. Chevalier? Yes. Mr. Connor?
Yes.
Ms. Gillis?
yes,
Mr. Scarpa?
Yes.
Chairman Sullivan?
Yes. Okay, as I previously stated, item number 5 is going to be moved to the end of the meeting. We'll move into the applications under item 6. The first one we have up, I will call in, it's 15-19C, Metro Storage LLC, located in the OG1 zone, Route 9 and Cindy Street, 3-story self-storage facility. Preliminary, final, major site plan with C&D variance. John Wicascal is representing the applicant. This is for vote only this evening. All the testimony has taken place. Both attorneys, as this was an objector's case, will get a chance to make a summation. Is that correct, Mr.
Yeah,
Sachs? Would
that-
you fill me in on anything I missed?
Yeah, that's correct, Mr. Chairman. We also closed the public portion at the last meeting, so at this point, it would just be summations and then a motion on this application. So, Mr. Gazarovski, since you're the objector, we'll let you sum up first, and then we'll let the applicant's attorney sum up.
Mr. Chairman, you have no objection to my sitting?
No.
Why, absolutely not, please.
Thank you.
I am. You might as well be.
I'm older than you, so.
Okay, well, we're not going to arm wrestle, are we?
Pardon?
We're not going to arm wrestle. You go forward, sir.
Mr. Chairman, members of the board, my name is Ron Gazarovski. I represent objectors in this matter. I think you've been here 4 or 5 times, so, and I know you've paid attention every time that I was here, so there's really very little that I can say, or should say. In accordance with your zoning ordinance, this is not a permitted use, but under the terms of your ordinance, it is a prohibited use. And when governing bodies reflect the use as being prohibited, I think that's of great significance. So the applicant is here before you today for a use variance. I think what is also important is that the board, I'm sure, took note of the many objections of the neighbors who are in this surrounding area. They were here every time, they testified, they prepared exhibits, and they're greatly concerned what impact this application will have upon their property, their citizens. I think what is also significant is that this is an undersized piece of land, and it is not a permitted use. You have other areas in your municipality where this particular use is a conditionally permitted use on larger pieces of land. In addition to that, not only is the applicant seeking a use variance because it is not a permitted use, but he is seeking other variants as well with regard to height, with regard to parking, setbacks, and/or the like. So obviously, as an objector's attorney, I've been down this road many times. I think there are significant challenges to this property. I think the applicant could have made an attempt to purchase a different piece of property in another area of town where this was a conditionally permitted use. I would suggest to you that he bought this piece of property or signed a contract to buy this piece of property because financially it was basically the best deal that he can get. But that has a great impact upon those neighbors who live adjacent to and around this property. They've done nothing wrong. They are complying with your ordinances. They are your citizens, and they're before you asking you to simply enforce the existing ordinance as it stands and deny this application. This is not an inherently beneficial use. There's a warehouse. That's all it is, plain and simple. There are other areas in town where a warehouse could be constructed on a much larger piece of property, but significantly, not only is the applicant seeking a use variance for this property, but he's also seeking to build the building higher than what is permitted under your zoning ordinance. He's also seeking to seek relief with regard to parking spaces and the like. So taking all of those things into consideration, it's easy for me to say this is, it should be an easy decision for the board. but it never is, because boards always want to give an applicant as well as an objector a fair shot. And I think this is a fair board, and I would implore you not to grant this use variance. It's contrary to your master plan, contrary to your ordinances, and it'll have a significant adverse impact upon property owners who, for the most part, the greatest asset that they have is their home, and this will adversely impact them. Thank you.
Gazarovski? Mr. Wixell?
Thank you, Chairman. Good evening, everyone. John Wichiscala on behalf of Metro Storage LLC. It's my pleasure to be back before the board this evening. I would like to start by thanking the board, board secretary, and the board professionals for the time and consideration and thoughtful commentary that has been offered during the course of this application. We've accepted a lot of those comments and feedback that we have gotten, and we have revised the plans over the course of the hearing based on those comments. We think improvements to the plans from what had previously been submitted. I am honored to be before you tonight on behalf of Metro Storage. I have worked with Metro Storage on numerous projects here in the state of New Jersey, and I do hold this company in the highest regard. It is a family-owned business. They have been in the business of self-storage for about 43 years. And as I stated on the first evening, they operate approximately 140 Class A self-storage facilities throughout the country, primarily Midwest, Northeast Corridor, Southeast, and the like. The subject property of this application, it is not an undersized property. It is a substantial piece of property at just under 10 acres in size. This is a property that is located along one of the township's primary and busiest highway corridors in Route 9. It is a property that is located in your OG General Office Business Zone District. This is a zone district which your master plan indicates encourages developments that provide services to the residential and business communities through a variety of land uses. This OG zone is a zone that does permit many high-intensity land uses that can generate significant traffic, noise, light, pollution, and other impacts to surrounding properties. As you heard over the course of the hearings, the various uses that are permitted in your OG zone do include general office use, medical office use, hospitals, urgent care facilities, medical clinics, bars, restaurants, taverns, and the like, hotels, and a host of other commercial uses. It is a site that is located adjacent to a residential zone district and residential properties to the rear. As we discussed throughout the course of the hearings, I think it is uncontroverted that self-storage is among the lowest impact land uses I think you can find with respect to development. And again, by low impact, I'm speaking from the perspective of traffic generation and noise generation, trash and recycling, and general demand on municipal services. And candidly, a lot less than some of those other land uses that I just mentioned that are permitted and would be a permissible development on this subject property. We do believe the development of a self-storage facility here is an ideal land use for this site. It's on a busy highway. We've heard comments about how busy and dangerous Route 9 can be, but it's also adjacent to a residential zone district. And we think the advantage there, again, is the low-intensity nature of the use itself. We believe it is evident from the testimony you heard from our professionals over the course of the hearing. You heard from our civil engineer, Brad Bowler. He offered testimony on several of the evenings with regard to the overall site development. As noted by Mr. Bowler, it's an approximately 10-acre site, but our proposed development is really limited to about a 2.5 to 3 acre portion of the property as a whole. The intention of the applicant, as we indicated at the outset, is that the remaining portion of that property, which is in the 6.5 to 7 acre range, the northern portion of the site, would basically be preserved and remain undeveloped in its current condition. Relative to the site plan itself, we do believe we've done everything and put a lot of thought and time into working with the existing landform and the existing topography to come up with a project that we think limits the access or the impacts to the Route 9 frontage, as well as limiting the impacts to the residential properties to the rear. We have been very cognizant of our residential neighbors to the rear. Particularly, we've got those 3 or 4 homes that are directly behind the portion of the property that's going to be developed. And we've also heard from the other neighbors that are just along the portion that's to remain undeveloped. As we did discuss on the first night of hearing and through the exhibits that we presented, that we are proposing a 3-story structure, and we're now at about 32.9 feet. Your ordinance allows 30 feet. Due to the topography, the sloping topography of the site, those residential properties on the rear portion are really looking at the functional equivalent of a 2-story structure that's probably lower in height than most of the other single-family homes that are within that general development area. Over the course of the project, we also scaled back the scope. And everybody may recall, we originally had 2 buildings. We had a standalone, single-level building along the rear that had been located within that required 50-foot rear buffer to the residential homes. We heard the comments of our neighbors, their particular concerns regarding maintenance of that buffer. And as a result, we came back before you, and I think it was at our last meeting that we presented the amended plans that eliminated that building, that fully complied with that 50-foot buffer. We didn't propose just to put grass in there or low plantings, but proposed a significant evergreen buffer, which would be in addition to the existing trees as well that are between the 2 properties. We also agreed, based on your comments of your township forester, that we would work with them to do, and them and your engineer to do additional berms that would also further limit the visual impacts that those residents would have with respect to the project. The elimination of that building reduced the nature of the FAR variance. We eliminated virtually all of the signage variance, and overall, from what we originally had, reduced the size and scope of the variance relief. Mr. Bowler spent a significant amount of time talking about the stormwater management and drainage system. That was a topic of discussion both with the board and the residential neighbors that we have. This project is designed to meet the township's requirements as well as the DEP's stormwater management regulations. And I believe the board engineer agreed with those findings. We are also subject to DEP jurisdiction and approval, and we've got our permit applications in before them. We are cognizant of the issues that the neighbors raised at the last meeting. We saw a lot of pictures of existing homes with, various states of ponding and so forth in those backyards. You did hear testimony regarding topography from our engineer at some of the earlier hearings. It is evident to us that, a number of those properties do have, low topography. They've got low-lying areas with limited grading or limited slope. We are aware that the soils conditions in the general area are very poor. We know that just from analyzing the soils that are on our property. We didn't do any soil analysis, but it would stand to reason that the adjoining properties share the same characteristics and that they really just don't allow immediate infiltration as you would have if you have a better soil condition. But the one thing we can say with certainty, and my engineer said it, our project is not going to impact those properties. We are not going to exacerbate any conditions that exist on those properties that are to the north, and I think it's from lot 35 on. And from the perspective of the folks, Mr. Ahern and the other folks that live directly behind us, their property slopes in our direction. They're at a higher ground than we are. So our project will not have an impact from a drainage perspective. You heard from our traffic engineer, John Harder. He discussed the traffic impacts and his findings regarding trip generation to this particular site. And he concluded that this project will have no appreciable and no detrimental impact to the road system, and in particular Route 9. Mr. Harder's report was based on the ITE, the Institute of Transportation Engineer trip generation manual. And what he found was in the morning peak hour, that busiest hour in the morning along Route 9, this project would generate a total of 13 trips. That's not 13 cars in and out. It's basically 8 cars entering the site, 5 cars exiting the site. If you do the math, It's basically one trip, either in or out every 4 minutes during that peak hour, which of course is always the hour that any board looks at. In the evening weekday, we were looking at a total of 23 trips. So in that PM peak hour along Route 9, we're talking about 11 cars in, 12 cars out. Roughly one car every 2.5 minutes would be coming and going from this facility. Highest projection was on the weekends during the peak hour on a Saturday, which was roughly 41 trips, one car every minute and a half at that busiest time. This project certainly will have no impact on any of the other roads that are within the area, certainly not any of the residential streets. Fernwood Place, Chelsea, Valley Vale, Elmwood Place, there's no access and there's no means of vehicles coming through those neighborhoods that would have any impact. You did hear and see that the project did receive a DOT permit. So DOT looked at this access point and there are comments about the appropriateness of the location. It's a state highway, it's DOT jurisdiction. DOT certainly in looking at this has their standards. And if the DOT did not believe that this was the best location for it and a safe location for this type of land use, they would not have issued the permit that they did back in November. Beyond what Mr. Harder said on traffic generation, you heard from Bob Heilman at our last hearing. Mr. Heilman basically came here with business records to show what the real trip generation is, and he selected a site on Route 22 in Springfield. It is a metro facility that's been in operation for about 3 years. Fully operational, comparable in size, comparable, has residential properties and other commercial uses proximate to it. And over the course of that time frame, the average visits during the day, Monday to Friday, 30 customers total. I'm not talking in a peak hour, but I'm talking about 30 customer visits from Monday to Friday, and a total of 45 customer visits on a typical weekend. Those numbers are significantly less even than those ITE projections that Mr. Harder had testified to. And what they really support as well is the request we have, the low demand for access to the facility and the low demand for parking. And that's what justifies the parking variance that we've requested. Finally, you did hear the testimony of our professional planner, Nick Graviano, in support of the D1 use variance, in support of the FAR variance, and the various bulk variances that we have. And listen, the majority of your bulk standards are complied with here. A number of those variances relate to light pole spacing and various other aspects. But as discussed by our planner, we do believe the site is ideal and particularly suitable for the proposed use. He spoke to special reasons. He spoke to the master plan. We do believe that the project satisfies both the positive and negative criteria, which you hear about and consider all the time. We believe that the benefits outweigh any detriments that may be associated with granting the relief for the development of this site, and that the variances can be granted without substantial detriment to the public good and without substantial detriment to the zone plan and zoning ordinances of Old Bridge. If approved, this project is going to take what has been a long vacant parcel of land along your primary commercial corridor and put it into utility. It will result in a significant fiscal benefit to the community for a land use that has a very low impact and virtually no demand on municipal services. In conclusion, we think it's a great development for this parcel. It's a self-standing facility, fully sprinklered, fire and security systems, cameras throughout the site. Significant landscaping is being proposed, particularly in that residential buffer to the rear. We spoke to the lease and the stringent requirements we have relative to our customers, what they can store in the facility, what they can and can't do there. We spoke to the restrictions on access with a facility that cannot be accessed between the hours of 10 p.m. and 6 a.m. In the morning. Again, we understand the concerns of our neighbors. Change is tough. I know they've become accustomed to just having woods behind their property, but it is a development parcel that is zoned for commercial use. I can say, knowing Metro as I do, if this board were inclined to grant the approval, and and this project was to be built, Old Bridge is going to have a reliable corporate citizen and a neighbor in Metro. They are responsible builders. They are cognizant of their neighbors. Once built, what you're going to have is a facility. It's going to be well-run. It'll be impeccably maintained, including the buildings, surrounding grounds. It will be a safe and secure facility. And I am confident that the neighbors in the township would ultimately find Metro to be a quiet neighbor and one that will have a positive impact on the community. Again, thank you very much for your time, consideration on it, and obviously, we respectfully request that the board grant the approvals that are requested this evening.
Thank you, Mr. Wicascala, for your summation, and you as well, Mr. Gazarovski. The only thing left before the board this evening with this matter is going to be a vote, and before we do a vote, I'm going to have Mr. Sachs inform us as to what we're going to vote on. Before I do that for the final action, I'm going to allow commentary from the board, and I'll begin. I offer my commentary to all the involved professionals in this application, not only from the applicant's side, but also those representing the township, as well as those representing the objector's case. I thank you all in advance for your professionalism, presentation, and patience to impart your knowledge and opinion to the board so that we might perform our duties and render an informed decision. I also offer my thanks on behalf of the board to all the residents of our great community that took the time to participate in this governmental function that on occasion lasted well into the late hours of the night. We realize that your comments and your feelings are based on your own passion in pursuit of property protection and rights. Your words have all been transcribed and become part of the permanent record. The members of this board are all volunteers who reside in this township, and they commit to a civic duty. We are trained and certified by the NJPO, the New Jersey planning officials, and each takes an oath of office to uphold the laws of this state and the United States. A board-appointed attorney, Mr. Lawrence Sachs, sits as counsel to this body, and he ensures that our actions comply with the law. Most members have sat for years on this board, and they're well-versed in protocols and our duties as it applies to municipal land use law. Having said that, however, this particular application was somewhat unique in that it involved not only an applicant's position, but a parallel objector's case as well. Most of our applications involving use variance are represented by an attorney who prosecutes the case typically with testimony from principals, professional engineers, professional planners, architects, and other associated experts. Documents, site plans, engineering reports, planners' reports, traffic studies, environmental reports, and community impact statements are all presented to the same type of professionals that represent the township and its interests. Their professionals' reports are also submitted to the board members for review prior to the meeting date. Those professionals are seated to my right and to your left if you're in the audience. By meeting time, most of the questions have already been worked out, agreed upon, or settled before the board can take any action. All of those items, questions, and responses are then placed on the record in this chamber. As our lawyer is counsel to the board, so are professionals with their guidance as to zoning issues and municipal ordinance. But in this case, a third set of professionals, a lawyer, an engineer, and a planner, also testified against granting approval and cross-examining applicants' witnesses. So after 5 meetings, we sit here for the 6th time, but this time to act as arbiters and render a vote. This application began with testimony from Brad Bowler, a professional engineer who explained the site plan, the stormwater management plan, as well as walked the board around the site and adjoining properties. In his testimony on October 3rd, Mr. Bowler opined that there would be no impact to residential homes. I've referenced the transcript from that date on page 14, lines 14 to 25, and page 15, lines 1 through 9. Comments from township professionals Dargy and Drum followed Mr. Bowler's testimony. Mr. Bowler stated he had been an engineer for 14 years and he's licensed in this state for 12 years, as well as being licensed in 6 other states. Mr. John Harder, a licensed engineer in traffic, testified on behalf of the applicant on November the 7th. He explained traffic circulation entering the site, on the site, and leaving the site. He further explained that the New Jersey Department of Transportation has granted permit approval for a drive entrance from Route 9 onto the site. Mr. Harder has been a licensed engineer since 1993 and a principal in the firm for 25 years. Mr. Nick Garaviano, a licensed planner, will offer testimony in support of the application on December the 5th. He explained his reasoning for granting the use variance and other associated variances. He explained that many other uses permitted in the zone would come with greater intensity. Mr. Graviano's credentials included being a planner since 2004, a principal in his firm since 2017, and obtaining a Juris Doctorate in 2006. Attorney-at-law Ron Gazarowski made his appearance as counsel for an objector's case. Mr. Gazarowski cross-examined Mr. Graviano at 2 different meetings. He also cross-examined a principal of Metro Storage, Mr. Rybel Highland, concerning the operations of Metro Storage in other locations. On January 16th, the objector's case began with testimony by Mr. Gordon Gemma, a licensed professional planner since 1989 and a licensed attorney-at-law in the state of New Jersey. Mr. Gemma spoke against the granting of the use variance and associated variances. He disputed how the applicant's planner, Mr. Graviano, came to his conclusions. On February 6, 2020, the applicant submitted an amended site plan lessening the overall size of the project and eliminating some variances. Also on that same date, Mr. Gazarowski offered Mr. Brooke Crossan as an expert witness. Mr. Crossan is a consulting professional engineer, a licensed planner, and he holds a PhD in geophysical fluid dynamics. He states his experience is for 45 years. Dr. Crossan disputed the testimony of the engineer, proffering that, in his opinion, the improper runoff coefficient was used in calculations. He further thought that the wrong elevation for flood hazard area was used. He believes that it should have been determined by method 6 instead of method 5 by state rules. He added that boards, planning and zoning, should consider future climate change. He continued on engineers and their ethics. He also cited 2 executive orders issued by the governor, numbers 100 and number 89. I took time to research each of those executive orders. I found them both to be political pandering and hypothesis, neither one of which belongs in municipal land use law. Dr. Crossan was cross-examined by Mr. Wicascala concerning his belief that the wrong coefficient number was used in calculations and what he thought it should be. Dr. Crossan stated while it was tested, where it was tested was a D soil, but other areas could have been a B or C. I refer to transcripts from February 5th, pages 89 to 90, lines 10 through 25, and lines 1 through 20. Dr. Crossan admits he did no analysis on his own. A public portion was open at each hearing where residents abutting and in the local area spoke in opposition to the application. Most complained about pooling waters in their yards. Most have lived in their homes for years with the same condition, some upwards of 20 years. Some thought the vacant land was never to be built upon. Some now for the first time realize that many uses can occupy the land. I personally feel that an opportunity was missed by those abutting the project to work with the applicant and their professionals and perhaps abate some of their wet yard issues. All parties to this application, as well as the board members, are well aware that before any potential plan can be built, it must receive approval from the NJDEP. The board must now consider whether the proofs for approval have been satisfied. The applicant's professionals say they have. The objector's professionals would say they have not. The township professionals have said that they are satisfied with all the engineering and planning factors submitted, and all matters of their concern have been agreed upon by the applicant. Their findings have not been disputed. The objector's professional reasoning is twofold. One by Mr. Gemma, the planner, who states that a D1 use variance should not be granted as this particular use, a self-storage or mini-storage, is not approved use in the OG zone. That very reasoning, if followed, would invalidate the need for a zoning board of adjustment. The state legislature has not yet come to that conclusion. The second reasoning by the objector's expert in engineering matters, Dr. Crossan, deals with his belief that wrong calculations were used and perhaps wrong soil assignments used in areas beyond the bills that might affect the runoff. Unfortunately, Dr. Crossan did no independent analysis of his own. No other engineer involved in this matter agreed with Dr. Crossan's theories. With no disrespect to the learned professionals, I'm sure that both men in their careers often argued the complete opposite beliefs on behalf of applicants. Mr. Gem himself stated that he once sat on a zoning or planning board in his hometown. I'm fairly certain that he came across a D1 use variance and voted in the affirmative. To follow their reasoning is asking the board to proverbially throw out the baby with the bathwater, and I'm not prepared to do that. I find the applicant has met their burden of proof and that their site is suitable for this project. I welcome any other board members to make comments. Mr. Walker.
I believe the township had set up the master plan for a reason. And unfortunately, this project does not fit that plan. It's prohibited. So, I don't believe it's the zoning board's, we shouldn't be rezoning the master plan by issuing zoning like this. It doesn't fit. I also have, as a firefighter in town, I'm very aware of Route 9 and the safety issues. I attend many motor vehicle accidents on Route 9. That's a deceleration lane. And we've got the New Jersey Transit buses going up these shoulders now. I have no idea who in the state of New Jersey did that, but that's just a recipe for disaster. We've already had one accident because of that. I just don't like the proximity close to the jug handle. I just think it's a big safety issue. And I'm not convinced that the project is not going to harm. I don't want to see the homeowners have their properties become worse, and I'm not convinced at that point. And at this point, I am not convinced that that's going to happen, so I will vote no on this application.
Any other board members to my left want to be heard? Board members to my right?
Yes, I would.
Ms. Chevalier.
I'd like to address the same fact that the master plan was just reviewed in 2019, deemed not, consistent or for the purpose that the master plan wants. Second of all, although I appreciate all the revisions you did in your plan, the homeowners are still going to suffer with the building and the clearing of the trees and your planting shrubbery. And I'm sorry, in 20 years, most of these people will be moving into a retirement village before they don't have to be deafened by Route 9.
Anybody else on the board? Mr. Sachs, we now come down to a vote.
Yes.
I believe we have a D1 and a D4.
Yes,
And
D-
then we would have bulks, correct?
Yes, so it's a D1 for the use, a D4 for the FAR, several bulk variances. I think there may be one or two design waivers, and then preliminary and final major site plan. So I think it would be in order to deal with the use variance first, which would be the D1 use variance.
Okay. Board members, you've heard the explanation. The first vote will be D1 for use. Someone want to move it?
Motion?
Is there a second? I'll second. Roll call, please.
Mr. Dewhurst.
As I am not convinced that this is the best place for this project, my vote is no.
Ms. Chevalier.
No.
Mr. Conner.
Yes.
Ms. Phillips.
Yes.
Mr. Scogno.
Yes.
Mr. Walker.
No.
Chairman Sullivan.
Yes. It's 4-3 defeated, correct?
Yes, but just so the record is clear, let's vote on the other variance
Okay.
relief as well, which would be the D4.
Okay.
So-
That's the D4 floor area ratio, board members. Someone want to move it? I'll move it.
I'll second.
Roll call, please.
Excuse me, Mr. Sachs,
Yes.
do I just call everyone?
Call the roll again, yeah.
Mhm.
Yeah.
Mr. Dewhurst.
No.
Ms. Chevalier.
No.
Mr. Conner.
Yes.
Yes.
Mr. Scogno.
Yes.
Mr. Walker.
No.
Chairman Sullivan.
Yes.
Let's vote on the C variances and the design waivers together.
You can take them as
We can take them
one
as a
bulk?
block, yeah, that's
One
fine,
block.
yep.
Right, the block for the Cs and the design waiver. I'll move it. Is there a second?
Second.
Move in second, roll call.
Mr. Dewhurst?
No.
Mr.
No,
Mrs. Conner?
Yes.
Yes.
Mr. Scarpa?
Yes.
Mr. Walker?
No.
Chairman Sullivan?
Yes.
All right, and why don't we take preliminary and final together?
Okay. Preliminary and final together, you said?
Yeah, we could do it together, that's fine.
Preliminary and final site plan together. I'll move it. Is there a second?
I'll second.
Roll call.
Mr. Dewhurst?
No.
Ms. Chevalier?
no,
Mrs. Conner?
Yes.
Ms. Silva?
Yes.
Mrs. Scarpa?
Yes.
Mr. Walker?
No.
Chairman Sullivan?
Yes. That covers it all, right?
Yep.
Thank you very much,
Thank you
Chairman.
very much.
Thank you.
Just so we're clear.
Yes, sir.
The appli-
It did not grant the use variance.
The application is denied.
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 The application is denied. Yeah.
Thank the board for its patience, and I respect your consideration that you gave to this.
Just seeing you, Ron.
Good night. We're going to take 5. I think the stenographers are going to change, correct? We'll stand at recess 5 minutes.
Here.
Here.
Mr. Walker?
Here.
Mr. Psychowski? Here. Mr. Stoner?
Present.
Chairman Sullivan?
Here.
Mr. Sacks?
Here.
Mrs. Shapiro? Here. Mr. Vaughn? Here. Here. No, I was just looking for. Mr. Lavalla? Here. Ms. Jones? Here.
Okay. We'll move back to item 6 under applications. This is 4-2020Z. 69 Ravine Avenue LLC. This is in the R5 zone located at 69 Ravine Ave. In addition to a single-family house, C&D variance, Bill Bajor, Esquire, representing. Sir? I hope I pronounced your name correctly. Thank you.
Good to see you, Mr. Chairman. William Bajer, actually, we were close. I
was
think
close.
there's a dispute even in my own family. I'm here tonight representing the applicant who's here in the person of Ahmad Atiyah, who's one of the members of 69 Ravine LLC, and also the accountant I'm giving you promotion, the architect who worked on the plan, Asef Ragab, who's here with me tonight. They're going to be sworn in and provide testimony.
Okay, gentlemen, please both raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, please state your name, spelling your last names, and address for the record.
Ahmad Atiyah, A-T-I-E-H, 149 Princeton Road, Parlin, New Jersey, 08859.
Thank you.
Ashraf Ragab, architect of record, 2 Division Street, Somerville, New Jersey.
Can you spell your name, sir?
Your last name?
R-A-G-A-B.
R-A-G-A-B, thank you. Okay.
Please be seated.
Briefly.
Yeah,
Waive
Mr.
the right to-
Mr. Bajer, obviously, it requires a use variance. Our rules require a court reporter to be present. However, you can certainly waive that requirement. I'm assuming you're going to waive that requirement.
We are waiving that
Okay,
requirement.
that's fine.
Thank you.
Mr. Atiyah, can you just briefly tell us about your background and your involvement in this property?
So my background on it is, originally born and raised in Old Bridge. Went to Old Bridge High School, Carlson Medical School, Madison Park Elementary School, so I've been here and I still live here. Pretty much my involvement in the project is I studied civil engineering in college, and now I'm working as I work as a project manager, but I also do real estate, and I do a lot of project rehabilitation. So the idea of the project that I had now was I was taking on the project in order to pretty much, if you see the condition of the property now, if you guys take a look at it, it's not in the best condition.
A1?
A1, yeah. He's the,
I think you should let the board know.
Yeah.
He's not testing, he's not testing as an expert, he's
He's not
testifying as the owner.
testifying.
He's one of the
Just
principals
art.
of the applicant, right?
Yes.
That's what I thought. Okay,
Absolutely.
yeah, okay.
So, as you saw in the property itself, it's not in the best condition, so the original idea to take on the project was to rehabilitate it, bring the property value, bring up the whole entire neighborhood value of it, and just pretty much take on a project and move to the next. My idea of it was, I've done other properties in Old Bridge, myself, actually the property next door, where we purchased it, We fixed it up. It was in bad shape as well, where we've done the roof, we've done all the type of work on it. I have even proof of, like the craftsmanship that we put into it, so it's not like we go in there, we just try to get work done and everything. We put value in our work, and we do everything that we want, like, just to bring up the value of itself. I've lived in Old Bridge. I want to see an improvement in everything that's here. So like if I see a house or anything that needs, like, that's in bad shape or bad condition, like a lot of the houses that are in the Lawrence Harbor area, a lot of them haven't been touched, like even past Sandy, anything like that. Like you look at them, they're a mess. Like that street itself, there's a few properties I need that, for this one, for instance, I was able to purchase it, and my goal is to bring up the value, bring up like just the elegant state of it from the outside and from the inside. Because right now it has 2 bedrooms, it's destroyed on the inside, and it's pretty much, it's not livable at the moment. The idea is to fix it up, fix the outside, fix the inside, and have it to be a livable home for someone to bring into Old Bridge. So if we can bring a new member into Old Bridge, that's happy and like pretty much has a new home, has their kids, everything like that. The goal is to bring people into Old Bridge and bring a new family. So in essence of going from a destroyed house to a new house, that's our goal in that.
Is there a reason why you're increasing to add a level to the house rather than working with the confines of what you have right now?
So right now, the house, we have it as barely 900, like it's 900 square feet. It only has 2 bedrooms, and they're very small, and it has the bathrooms in it, and the living room, and dining room area are shared, and so is the kitchen. So the idea of, like, the ideal home, usually of people when they come wanting to move, they don't want a 2-bedroom home. In case they have a family, in case they have kids or anything, it's usually 3 bedrooms. And to cut down on living room space or anything like that, everyone's gonna be on top of each other. So the proposed idea was to go on to the next level in order to have all the bedrooms and give it a nice living room, dining room area, as well as have a nice kitchen where they can sit and have, like, pretty much regular family, have a whole complete home to themselves. So the idea of going to this next level was just to add value to the house. Well, it also increases value to the neighborhood as well, but also add the square footage to the house, so you can have a bigger home for a family that comes in.
Can you tell the board about the size of the lot and some of the conditions on the lot that make improving the property challenging for you?
So, one of the biggest things is, yes, the size of the lot, it is smaller than all the lots there. A lot of them are a lot smaller than what's proposed. So if we take a look, for example, on the pictures that I have here, I have 2 pictures of the front of the lot. There's this one and this one.
Let's mark that A2 and A3.
Which one's A2, which one's?
Your choice.
A2 is slightly closer. I think A3 shows the house further back in the foreground, or
Yeah.
in the
So-
back. I'm sorry, that's 2.
So the issue is the house is set far back onto the property as it originally was constructed. The main part of the yard is in the front. There's no back. It's right on the edge. So that's the issue that we're having of it being right off the property line, of it being, right now it's 1 foot and 8 inches right off the property line in the back, which the property in the back is owned by Old Bridge. So it's right on the line. So we don't have that much space on both sides as well. So on the left side, we have, as shown in this picture, we have 4 feet. We can't really do much on the left side when facing the property. And then on the right side as well,
That's 3 over there, so this is A4.
and then on the right side, how the lot is shaped and how the building is shaped as well. The minimum area that we have from the neighbor and the property line itself is 2 feet and 10 inches, as shown in these 3 pictures. This is one. So we would show here, that's where the fence is and that's where the property ends. So that's where we have the 2 feet and 10 inches.
That's going to be marked as A5.
And I have closer ups. This is the alleyway of it going to the back. And then same thing for this, it's just a closer up picture. Oh, sorry.
Sorry.
Photographer or a?
And that's A7.
It helps.
Yeah, got a stack down there.
So essentially, it's the limitations that we have on doing anything to the property is whether we want to go, there's no going to the side, there's no going to the back, there's no going to the front, because where the condition of the property is right now, where the current state is and where it was built. Yes, it's on the, what we have, what's proposed by the zoning laws, it is in between those boundaries, which is over. But there's, in an essence, what we're trying to work with is trying to see is working with the current state building, what we can do to improve it and pretty much add the more square footage to it. So this is the back, this is the current backyard of the property. The property line is right on the line. I'll show another picture as well. But the lot in the back is where the property ends is right on the line. So the property in the back is owned by Old Bridge Township as a
ROSI.
ROSI. So that's one reason. So the property in the back can't be used for any essence.
We're actually modifying our application in consultation with the board secretary, brought this to our attention. There was some hope that there could be an existing boundary agreement or some other agreement. There cannot be for obviously that type of space. So we're going to obviously remove the deck, relocate the condenser unit that's there to make sure it's fully sited on the property. And the rear door apparently is only a door to a crawl space with mechanicals. We're going to remove the stairs so they're no longer infringing. But the door apparently needs to remain. We're going to take some testimony from the architect regarding that issue because it's only used to access the mechanicals, which can't be put anyplace else. They can't be put on the exterior because there is no exterior really to speak of. And the door is going to have to remain. The stairs will no longer encroach. All of the rear encroachments are going to be removed. And we'll have testimony to that effect tonight.
Yeah. As shown in this picture, this shows a side angle of where the deck was that is current now, which we're gonna remove. And then where the steps are that lead to the door in the back. The steps are, we have a property marker, which we had from our survey done. If you can look in the back, there's a property marker that shows. So we're gonna have the steps being everything along, but as the door remains, the deck will be removed, so it'll still be off of the property line of Old Bridge.
And those stairs that are encroaching will also be removed and we'll regrade to allow access. Is that the plan?
Yes.
That's a yes, yes?
Yes.
Just so I'm clear, so what you're going to do is you're going to remove the deck, you're going to remove the existing stairs. The door is going to remain, but you're going to have a new staircase that'll be constructed, which will not encroach.
Correct.
Yes.
Okay.
Staircase to where?
I guess to the backyard.
So actually, the stairs are only going to be allowed access to the below-ground
Okay.
mechanical room, which is
Gotcha.
not going to have ingress or egress
Okay.
other than from professionals accessing the utilities.
Okay, fine.
What is the back of the house? How far does the property line extend backwards?
1'8".
1 foot, that's it?
1 foot 8.
1'8".
inches.
So no matter how you put the stairs, even if you put them sideways,
It's gonna,
it's going to encroach?
Yeah.
But I guess we'll get to that. I'm sorry, go ahead.
Yes.
Wait, how many his more is he?
I can cut down. A lot of them are repeats. But this is
Come down, yeah.
this is just an area of the backyard from the side angle of the house. This whole area is currently the Old Bridge Township's, what was it called again?
ROSI.
ROSI, sorry about that.
No worries.
This is currently the Old Bridge Township's property. One thing is, yes, you have fences on both sides. This property is already, it's not part of the Old Bridge RSI, but a lot of the properties on the sides are. And they've taken, I guess, certain account into just having the fence up just for maintenance and cleaning. Because a lot, during the summer and during like certain times of the year, this grass and everything does grow and it's not maintained. So it's kind of like, it was taken on our part to maintain it, to cut down the grass and everything. So I don't know if it's.
We'll hear from our professionals.
The fences were not erected by us and are not
No.
going to remain from us. They have nothing to do with us. Those are
No,
neighboring fences.
Those are neighboring fences. So none of the fences around are ours. It's just neighboring fences that have been there. Only,
Anything specific you want to add? If not, we're going to hear from,
no, pretty much, it's just, the intention of the project is, we want to take this smaller house and pretty much rehabilitate as much as we can in order to get a house where we can fit a regular-sized family into it, which is what we're proposing for more than 3 bedrooms, and then have a living room, dining room area, and also a kitchen. With the current conditions, we really can't, we've tried working around with everything, and it doesn't, from the square footage of the house itself, it doesn't really conform to what what we would say like a regular sized house or anything like that. So the intention was to go to the second floor in order to bring in that size to the house and bring in that value to it.
I know I did ask you to look at, through the neighborhood to find other houses that may have similar projects, similar extensions or build-outs. The character of the neighborhood is obviously important to the board. Can you tell us what your informal survey of the neighborhood seemed to show?
So the neighborhood itself, there's a lot of different variation of shapes and sizes of houses. 3 doors down at 65 Ravine, there is another house, same size lot. It is on the second floor. I believe the square footage is as well. I took a picture of it. Is as well, has a higher square footage than what is allowed zone-wise, but it is on the second floor. That's one property. And then down the street, on the side street that corners it, Shady Side Avenue, there is 2 other homes that are in the same picture, have a smaller size lot, but have also gone to second floor. So we have, one is 51 Shady Side Avenue, and then the other one as well is 27 Shady Side Avenue. So both have gone on the second floor, and both, as you can see, are the property lines and the square footage of the property itself are a lot smaller than what is proposed in the.
What were those addresses again?
One is 51 Shady Side Avenue,
Uh-huh.
and the other one is 27 Shady Side Avenue.
There was
And
also
the-
another one on Ravine?
And the first one was
65 Ravine.
65 Ravine Avenue.
This is the house you did next door?
Yes.
Yeah, the inside interior?
Yes. So, just on a side note, the house that I was talking about that we also redid, that was right next door, which was 70 Ravine, I do have pictures of the type of work that we put into it, so we don't go in there, we don't do just whatever work and just move on to the next project. We put quality into the work, so I put in a few pictures just to show you the improvements that we do to the neighborhood and the other projects that we do all around. And this was one of the projects that I did in Old Bridge.
How many photographs are on that handout?
Do that as a grouping?
Let's do it as a group, please.
Yeah, I have it paper clipped, so it could be a group. One, two, three, four, 5, 6, 7, 8, 9, 10. There is 38 photos.
38 photos, and Kim, what's that exhibit now? That's A what?
I forgot.
We did too.
When I sent it to her, it was written
13.
That's 14.
A14 is a series of 38 photographs depicting renovation work that you've done on property across the street at 70 Ravine?
Yes,
Okay.
it's right next door, actually.
Next
To
door?
the left of it. To the left of it.
And the address is 70?
70, yes. It's a weird, it's a weird road.
All right, okay.
Mr. Ragab, can you briefly give us your qualifications in the state of New Jersey?
Before we do that,
I'm sorry.
Do you want to hear from the architect first? Yeah. Okay. Go ahead, sir.
Sorry about that.
I didn't know whether she had some questions, immediate questions, but we'll hear from the architect.
Ashraf Ragab, I'm the principal of Amrag Design Studio, licensed architect in the state of New Jersey since 2001. Graduated in 1994 from City College of New York.
We'll accept his credentials.
You heard the testimony of the applicant. Can you reiterate and review some of the challenges of this lot in terms of existing non-conforming setbacks and what is proposed?
So the existing lot is undersized. The zone requires a 5,000 square foot, and the existing lot is 2,950 square foot, so it's significantly undersized. The house is located in the rear, in the absolute rear of the property, and the property is not a rectangular property, it's more of a flag shape, so it's narrow in the front and it widens up towards the back, and the house is pretty much locked into the wider area in the back with very little chance of any front additions. And that would happen to be the only area that has a conforming setback, which is the front yard, since the house is completely pushed to the back of the property. The residence, as Mr. Atiyah testified, is in a state of disrepair. It's vacant, not in a very good shape. It is a 1.5-story, so we don't calculate the attic, but it does have a small attic area with a stair that goes up to the attic. But all the habitable space is in the first floor. There is a crawl space under the house where some mechanical units are, and the only access to it is from that stair in the back facing the township property. And part of that, those steps are on the township properties. What we're proposing is simply to open up the first floor into an open layout, with the exception of one guest bedroom in the back, and have 3 bedrooms, 2 bathrooms in the second floor with a simple, straight-up second-floor addition. We're not proposing to go over, except for there's about a foot or a foot and a half in the back right side that we are just straightening the back line of the house over. So we're going with a straight-up second-floor addition that includes 3 bedrooms, 2 bathrooms. Downstairs would be kitchen, living, dining, family, and a guest suite with a bathroom that's shared from inside the guest suite and from the outside. And we're proposing a small laundry closet for a stackable washer dryer. The staircase is being relocated towards the front where it's easily accessible from the main entry. The footprint of the house is not being proposed for any changes. We are keeping the existing footprint, and we're going straight up. The reason for the change in the square foot area from the first to the second is because of that indentation in the back that we're straightening it out. So the second floor is about 5 square foot larger than the first floor. That's about it.
You know, the reason that the use variance is being sought is for the floor area ratio.
Right.
Can you give the board some testimony regarding the floor area ratio, why it needs to be done this way, if there's something we can change or alter in order to have it be more in compliance, you know, and why we ended up where we are now?
I mean, what we're proposing is the easiest in terms of construction, and what we believe would be the most suitable for just going straight up. The only way we can reduce the floor area ratio is by cutting the second floor area, and that would complicate the framing a little bit, but I mean, it is doable. The floor area ratio, this variance is not really a result of the size of the house. The house, the proposed area of the house is only 1,800 square foot, but it's because of the lot is severely undersized. So for a normal sized lot, this house would be more than suitable in size.
And with regard to the various bulk variances, all of those are existing non-conforming?
All of them are
None are
existing.
being exacerbated by the project?
No, we're proposing a straight up second floor.
And there'd be no cantilevering or anything else other than the one adjustment to the wall that you discussed earlier?
Yeah, the area in the back on the right side, and that is not being extended. It's basically straightened out from the first floor. So we're not really going over the footprint in any area.
Drawings are up there for what is proposed. Okay.
Mr. Atiyah, just quickly.
Yes.
Obviously, you've heard us talk about the master plan, the ordinance, and the D variance, what that's required, the use variance. Generally, you're talking about something about whether it's promoting general welfare of the neighborhood, general welfare of the area, and whether the site can accommodate, you know, the addition we're proposing. Can you speak briefly about I know you talked earlier about having extra bedrooms, and you also talked briefly about just the nature of the project, what you're going to do on the second floor?
Mr. Baser, I'm assuming you're asking that question to him as a layperson.
As a
And not as
layperson.
a professional planner.
Obviously, there's not planner testimony here.
Okay.
That
All
is
right.
definitely the case. I appreciate
You
counsel.
can ask him, but it's, obviously given the weight that it's entitled to.
Yes.
Okay, fine.
So, essentially is from my working knowledge and everything on that part, what we're doing is we're improving the current state of the home. So you're gonna see a whole remodeled house from the outside and then from the inside. So that does bring value to of itself. And when it's sold to whoever the new family owner would be, that'll bring value in itself and it'll bring up all the value of the properties around it as well. So it's not like from the current state of what it's valued at, it brings in a real estate mindset. I do have a real estate license as well. It brings on the value of the whole entire neighborhood. But bringing up a property from its current state and bringing it up higher, you do bring up value to the neighborhood and you bring up value of itself. So the idea is to go from a vacant property to one that's that's not livable at the moment, to improving it, to bringing in a bigger property that improves not only that one property, but improves the whole entire community as well. So going from one house, bringing it up, you can bring up the value of the entire neighborhood in of itself. So the ideal situation is go from a 2-bedroom to plus. So we're trying to do 3 plus a guest suite. So it brings up the value of the house, but it also brings up, it's more comfortable for a new family to come in from them to having, instead of cramming into 2 bedrooms and a small living room, to having an actual full home. And like he said before, we're just going straight up. We're not going side, left, anything like that. We're going straight up the way the building is, and then we're going from there.
I have one other question for our professional tonight regarding the parking. There is currently no on-site parking, and that's going to be addressed by the application. Is that correct?
We are proposing a 9-foot 2 by 25 asphalt driveway in the front to accommodate some off-street parking, yes.
You can accommodate 2 cars on that driveway? Because what's the RSIS requirement with 4 bedrooms?
It's over 2,
Yeah, 2.2?
5, I think.
2.5, all right, but,
2.2 is for 3 bedrooms.
all right, so 2.5, but you actually scale it back, so as long as you provide 2,
Yes.
I think we're okay.
We can
You can
provide-
accommodate 2? Okay, all right, thank you.
And there's currently no existing on-site parking the way the lot is configured, correct?
There is none, no.
It is street.
Subject to further questions from the professional that they're certainly here to
Do
answer.
you own title to the house?
Yes.
Close with it being encroachment on the township's.
I can actually answer that. We
Okay.
received the survey the day or two before the closing. There was an accommodation made from the seller, which was a foreclosed property or a bank-owned seller. There was a financial accommodation, so we knew it had to be addressed. We would have been back here one way or the other. If we didn't do anything, it had to be taken off and addressed, but it definitely was one that came up on a survey at the time of closing.
Title company prove that?
Title company approved it as an exception. They accept it and don't provide coverage.
Might have recourse there.
Yeah.
I'll go to our professional, Mr. Wong.
Good evening, board members. First, I agree with the applicant that the property needs to be rehabilitated, revitalized. The existing home is not in the best shape, and there are nicer homes in the neighborhood, so definitely it needs some special treatment. However, I have a lot of concerns, and I'll just start with first one of the questions I had raised in my review memo too, that is that the applicant should testify if the overall character of the neighborhood is, if this proposal is consistent with the neighborhood characteristics. And I say that because the board is quite familiar with undersized lots in R5 zone. We have reviewed many such applications. We typically note that most of these parcels in the R5 zone, especially in the Lawrence Parkway area, are within the range of 2,500 to 3,000 square feet. So we have seen similar applications in the past. Here, the issue is more to do with, is it consistent with the streetscape, the neighborhood? One thing I noticed that all the other homes in the neighborhood are set back at 20 feet, which is the requirement of R5 zone. This existing home is set back almost like 55 feet from the property line. Now, to add to it, it encroaches into the township property. And it's not just the township property. This parcel is on our recreation open space inventory, which is listed under Green Acres. And I have worked with Green Acres in the past. They have very stringent requirements. Once your property is on the Rossi, you are not allowed or not permitted to use any portion. I know the applicant said that we want the ability to be able to mow or maintain that area. That's not allowed. It's not permitted. So the township property has to be left in the original state. When I was actually researching on this area, I also noticed that the neighboring properties have similar encroachments. In fact, people have gone down and put in a fence and created a nice backyard. They have been using it as a backyard, which they're not supposed to use. So if the board approves, or should the board look favorably on this application, I would recommend that there should be no use of the township property. It is on the Rossi. It has to be maintained in the vegetative state. It can be used by the township as recreation or a park, but it cannot be used by private homeowners. When I look at the setback requirements and how far this home is set back, actually, I would recommend bring down the house, demolish the house, and build a new home. It will be worth more in value, plus it will be consistent with the neighborhood. And then you will have a nice backyard, because if you move your home to 20 feet, you will have a 30 feet backyard, 31 feet to be precise. So you would be able to use that backyard. In this case, you're not going to be able to use the backyard at all. And so with the FAR, now, in the past too, we have seen similar applications where R5 zone requires you to request FAR variance because the lot is so undersized that it's physically not possible to fit a home. If you had to fit in a fully conforming home on this lot, excluding the side yard setbacks, I'm talking about just the floor area, you would be allowed a 1,200 square feet home, which is tiny. But then to put in a 4-bedroom home on a 2,900 square feet lot, to me, is a little too much. So I looked at, in fact, I went through the tax records. I looked at what the neighboring homes are, and there's only one home which is on a similar size lot that exceeds the FAR requirement, and that is at 0.48. So again, we have to keep in mind the overall characteristics of the neighborhood when you're proposing new house. So I think I covered most of my comments. If the applicant decides to proceed with the application the way it is proposed, I would recommend that they put in 3 posts at least, 2 at the corners and 1 in the center along their property line, and there should be a condition that they cannot use the township property. There cannot be any mowing of lawn or any use of that space. With the parking, actually, Nicole and I had a brief discussion on it because I did go to RSIS. I checked, you need 2 parking spaces. In this area, especially it's a cul-de-sac, the street is a cul-de-sac, there is some room, there's some shoulder space where I noticed that other residents have been parking, and they put the second car in there. So I didn't offer to comment because one car can be parked in the proposed driveway and the other car could be parked in that shoulder space. So parking wasn't a concern for me as much as the overall project or the overall characteristics of this project was.
Is there any place that they can find access to the utility room besides where it is?
let me check.
Now they have
Let
to
me go back.
enter onto the township's land to even get in it. I don't know what it looks like. Do you have a picture of it?
Yes, one of the,
Downstairs in the utility room?
oh, downstairs in the utility room, I have the outside picture.
Saw that.
Yeah.
You could move it actually to this corner where you have a niche and you could have your
Would have to dig, yeah. Anywhere
doors
else, we
there.
would have to dig under the footing, and
Well, I don't know what it looks like when you walk in there. Is it the entire space of the house?
It's half the house.
half the house.
Yeah,
Okay, which half of the house?
the back half.
I think we have a plan. Right?
The,
you know where-
You
It's
mean
on the
talking about
floor
from front to back or side to side?
It's on the floor, it's
yeah.
on the floor plan there. I mean, there is a basement floor plan.
But
Right
what I'm
next to it.
saying is I have that here.
Yeah.
Yeah.
Here's your access now.
Yes.
Okay.
I'm seeing.
It doesn't look like you could put it over here because you have too much going on. You're putting in new,
There's not enough room either. Yeah, yeah. I mean, you got 2
and there's
feet.
not enough room over here because
No, I think this is the place where they could put without affecting the existing setbacks. But, I mean, if you are going to dig and put an entrance there, why not just tear down the building and, create a better plan?
Problem is that tearing down the building and pushing it towards the front, we would actually lose area, not gain. The square footage of the building will have to be reduced because it is right now sitting in the wider portion of the property. The property narrows as it goes to the front, so first of all, we will end up with side yard setbacks on both sides no matter what, because we cannot accommodate, I mean, you can see the dashed lines of the setbacks. We cannot fit a house within these 2 dashed lines. And secondly, the square footage of the house will be much smaller, or we would have to go with a much longer and narrower house. It would be maybe like 19 or 18 foot wide by 50 or 60 foot long. And it's a much less favorable layout than what we have now, which is existing. So why would we tear down an existing house with a nicer width and push it towards the front, narrow it down, and elongate it into a lesser layout, not as good layout of a house. So that was the reason why it made more sense to leave it where it is and just go with the second floor over it.
Addressing the other concern, the township property will be left exactly as if it was almost wetlands. You're gonna have to be aware of that. Don't touch it, don't mow it, don't maintain it, it doesn't belong to you. We certainly will consent to that. That certainly can be part of any resolution. There's no, it's not an
it
issue
very
with
well
that.
be, but practically that's not going to happen. Right. Let's face it, he's selling the house, he's not going to live in it.
Correct. I mean,
So whoever's going to come in is going to cut out their own backyard.
And I'll tell you, if the township decided to put a fence up on
stops
its
it. That
property.
stops it.
Well, no, that stops it, but what it effectively does is it gives you a backyard of less than 2 feet. I'm concerned even from a fire safety standpoint, if the fire department ever needed to get to the rear of that house, there's no room.
well, I think the mechanical room situation is going to have to be addressed.
Yeah.
It's still gonna be next to a house 2 feet away. They still wouldn't be able to get to it because the setback on the side, the 2 houses are so close together. But to the extent that that's a better solution, we're certainly willing to explore that.
I just would like to add that in the past, I mean, when it has been an undersized lot, we typically haven't had applications that had basements in this area. It would be ground plus 1. So, I mean, and in fact, you're fortunate the township revised their ordinance just a year back when we eliminated basements or usable crawling spaces from the FAR calculation, because otherwise the overall FAR would have been much, much higher. So,
I believe this, what's the height of that space?
Less than 6 foot, yeah. We would count as a habitable space no matter what.
okay.
It's basically a high crawl space.
Counsel, let me ask you, does your client want to maybe reconsider this plan based on some of the comments made by our professional staff?
I don't think the demolition is an attractive option. the shape of the lot, it's 25 feet in the front, it's 35 in the back. So when they originally built it, they tried to exploit the 35-foot portion, because the 25-foot portion makes it a bowling alley, as the architect indicated. So I don't think that is attractive. Certainly, we're open to other suggestions that my client is amenable to listening to tonight or in the future. But the demolition one doesn't seem to be an attractive option for us.
I saw one of those similar type bowling alleys over here.
I've spent a few hours in bowling alleys in the past.
I mean, there are some shotgun houses in Lawrence Harbor, yeah.
I saw a two-story, I'll find it in here.
Well, those are the photos of what he's done. You might
Yeah,
be
that's
right,
where I
sir.
thought I saw it in there. Right here. On Exhibit A12.
I think from looking at her map, I think her point is that that
No, what I'm
lot
just
may
saying,
be.
is this is your exhibit.
Yes. With a second story.
Could move the house forward and have a similar setup.
But that's the one that is that the one that she said was above the existing?
I don't know, sir. It's your exhibit, I don't know.
I was on Shady Ave, yes.
I mean, one more suggestion would be to slide the house slightly in front, because there are other homes on the street that have lesser setbacks than what you are proposing. So you could still ask for a side yard setback variance and have your utility room, but just slide the building closer. Maybe not at 20 feet, but you could still move it till where the, what's that?
Vina,
The
you're talking
condos.
about, because I think the two houses on either side only have like a 20-foot setback, front yard setback?
No, I'm talking about the side setbacks.
No, but what I'm saying is that the two houses on either side of this lot are actually much closer to the
Yes,
street.
yes.
So that if the applicant decides to demolish the property and build a
That's great.
footprint equivalent to what the
Yes.
setbacks are to those other two houses.
Yes,
Yes, it would probably be, a longer house,
yes.
but certainly, right,
A better plan,
right, okay.
I have a question for Ms. Sawant.
yes,
This township recreational property that's in the back there,
yes.
can you get to it? Is it landlocked?
It's landlocked.
It's,
It is
What
landlocked.
good is it to the township if it's landlocked?
Part of our open space inventory.
If you
It
put
is
a
a part
fence
of our
there-
open
If you can't
space.
get to it, again, what good is it to the township?
And if you put a fence
I'm not too certain.
market, you would have to access through this property to get to it.
and it's
Wait.
also,
Give me 1 second, I'm actually trying to open the GIS.
also, the property after that, where you see in one of the pictures, right after is actually a ditch that goes down. So that's why I assume some of the people have taken whatever they are, but it's a ditch that goes all the way down into a creek or whatever it is. So it's the property that's Old Bridge, but then it goes down to a ditch to the remaining property. So either way, there's no access to it from any other location. So it's actually a ditch that goes down, I think, like 15 or 20 feet.
This fence that's around your property here,
It's the neighboring fence.
it is?
Yes, none of the fence is
It's
ours.
not landlocked. It's not landlocked, because
So the fence on the
There are-
right is the
these are
neighbor's.
A nice side out to the neighbor? They did.
They do, they have to,
Yeah.
yeah, you have to.
to answer your question, it is not landlocked because the township owns the neighboring properties too, so there definitely can be access to that property.
Thank you.
But they did build fences, so parcels are all cut up along the property lines.
Chairman
There's
Sullivan.
no straight access across this back area because each neighbor built a fence all the way to the back.
Mr. Shapiro?
Certainly, Ms. Sawant and I had conversations about the Rossi properties that were being encroached upon by the neighboring properties. The problem is when you have somebody coming in and selling a new home and rehabbing it, and now you're trimming the backyard, you're basically giving them permission to continue on with that. Vina and I were trying to see, well, what can we do to make this a little bit easier on the applicant? Nobody's going to walk out their back door, and I said, instead of a fence, because
Stop. You're gonna stop.
nobody's going to buy a house with a fence a foot off the back. But, what if we put like 4x4 wood posts with like, signage on it? The second the new buyer comes in, they're going to say, what is this? And they're going to plow right through it. They're going to look at their neighbors on either side, and they're going to put up a fence where they feel applicable. We can go back to the property owners that have, that have been there now. But on new property owners, going forward, everybody will sell their house. Going forward, we can fix it. Now is our opportunity to fix it. Registered open space in the eyes of DEP, they give us grant applications, grant money based on our open space. We have this whole entire inventory, so that we're trying to preserve this type of land. So it's, I know it's, people are saying it's not access. Quite honestly, it might all be wet, but that's even better. In the eyes of Rossi, that's even better, because now you're preserving open space, you're preserving, streams and wetland buffers and transition areas and stuff like that. So I would even, I agree with Vina in that if you're doing a rehab, do it right. Move the house a little bit up further. I understand the constraints on the property. But if you use the footprint of the existing building and go in front of it instead of behind it, or maybe even you can go behind it but encroach slightly behind it to give these people some sort of backyard. Nobody's going to want a house with 3 bedrooms if they don't have anywhere for their children to play. We don't want them to create that play area and then snowball it again in the future. Right now, we're turning over the property. Let's do it right.
Thank you, Ms. Shapiro.
By the way, Nicole, how many of those other lots are encroaching?
It's 3 other lots.
3 other lots?
Yeah.
I would make a suggestion, by the way, to Mr. Roselli,
Yes.
to send letters to these property owners, because I'm concerned about an adverse possession claim that could come up in the future. And actually, if you put them on notice that they're obviously encroaching, that prevents us from tolling any adverse possession issue.
I actually have reached out to
Okay.
Mr. Rizzoli already because I noticed that there are many such properties throughout the town where residences have been encroaching into these properties. So I did reach out to him.
All right, fine.
If, it would be the applicant's pleasure to take some of these comments to heart, have sit with the architect and look at some optional designs that may be more attractive to the board. I think, he's a good neighbor, he's an Old Bridge resident, he wants.
I'm sure he is, and I'm sure
we
he
want
wants to do the
goodwill.
right thing, and
We do.
it's admirable that he wants to undertake this and rehab houses for future use and future inventory for sale. But I think that the concern of I'm going to go to the rest of the board and see if they may have some things that they want to say as well. I guess you don't have any more direct testimony right now. Okay. Why don't we just feel that out, and then you can make your decision what you want to do. Of course, I'll get a
I
public
appreciate
portion
it,
as
Jim.
well. Board members to my left about this, anything?
I think it's a good idea that they go back and look at it again and see if we can come up with a little better option.
I'm just not comfortable that I think you're going
Take
to
it this
sell
time.
that to somebody, and they're going to think, this is my backyard, and then they're going to run afoul, and then this is just going to exacerbate the same situation that's going on now. And they're going to put up their own fence, or they're going to, and it would be, in my mind, if I bought the house, I'd want to be able to use some land behind it as well as in front of it. But in front of it, I'm not going to let my kids run around. I'm probably going to want to have a backyard. Board members on my right.
I feel exactly the same way. It's got to stop here, it's got to stop now with people encroaching.
Mr. Psychowski, you can be next.
I agree. I think it needs to be fixed now. I think the plan's wonderful, but the backyard is concerning. But I do think that I know it's not it's not appropriate for us to decide at this time, but I think that maybe a compromise should be made, especially if what you're saying is correct, that the land is landlocked and it's really of no purposeful use at the moment.
Thank you.
I have a concern too.
Mr. Stoner.
In one of the pictures, right? Let me see which one it is. It was the front. There's a house right next to it, right? And it's so close, and I don't know, that's the bedroom window? So I guess there would be no privacy for that neighbor?
The one on the right or the left?
On the left.
The one on the left, the house is set back a little bit. The one on the right, it's right on their property line. So the one on the right is right on the property line. So either way, if the right where it is, it's privacy. No one sees the house. If it were to move up, it'd be right on the side of the house and right on the other side of the house. So the
Those
neighboring-
houses are forward on their lots. Ours is set back on our lot.
I
They were
know,
built.
but see, what's gonna happen is, if somebody move in, right, they got kids, I would think they'll be in the front because there's no room in the back, right? So that neighbor won't have any privacy, right?
Right.
Oh, if the kids were playing in the
Kids will
front
play in the
lot,
front,
which-
yeah, absolutely, I agree, yeah. I
But
agree.
they're gonna be equally with another window 2 feet away from them. It'll be
It's Lawrence
maybe just
Harbor.
as bad. The kids are gonna be out very rarely. The windows are gonna be occupied probably most of the time. It's a Hobson's choice, I agree.
Yeah.
That certainly is the nature of the harbor, of the older builds down there.
Other towns deal with it a lot more
All
frequently. We're
pre-existing,
spoiled.
non-conforming, situations.
We don't deal with it quite as often in
Yeah.
other parts of town.
Yeah. Having said that, you guys are gonna have to reconsider on what you wanna do, unless you want to take a vote tonight. Either
Oh,
way, I'm gonna go to a public.
That was my suggestion. I think I already have the consent to
Okay, let me
adjourn.
just get a public opinion. Maybe there's something, we'll see.
Yep.
This is a matter of 4-2020Z, located at 69 Ravine Avenue for an addition of a single-family home. Anybody here in the chamber this evening want to be heard? Okay, no one has. We'll close the public portion.
That's good.
Thank you.
Okay.
So, Counselor,
That is our-
your
Your
client's gonna
Our plan to take a look.
bring something back to the board?
Yep.
Listen, this is a friendly board that welcomes people rehabbing their own homes here in the community and staying here rather than leaving somewhere else. So if you make an attractive home, I'm sure you're gonna do well on it. And I think you've already set the tone that you've done this in the past. So I welcome you to do this in the future and make this the right property. Consider moving that forward. You might have a better
That's the goal.
access for everybody.
The properties that we've done and everything, the goal is to just improve it and bring in
Well,
like.
Thank
bring
you
in
for your
stuff.
sincerity and.
Thank you.
and hold on one second, we've got to get another date.
May 7th? Yeah, that's fine. What day is that? That's a
Thursday.
Thursday?
It's always a Thursday.
May 7th on a Thursday? Yeah, that should be fine.
Is that okay? That's okay with professional, May 7th. We're going to, it'll give it, that's enough time.
Yeah,
Please.
if there's going to be a radical change to the plan, you'll have to renotice. Okay, that's fine, yeah.
So you know that. So right,
It's a different plan.
we're going to have to say that, right?
Yeah, yeah.
Okay, 4-2020Z, it's going to be continued May 7th. That'll be with further notice. If you're here on that matter, please take note.
What's the deadline for submitting revised plans?
10 days,
10 days before the hearing. 10 business days or calendar days?
10 calendar days.
Calendar days.
Yeah.
Thank you.
Thank you very much.
Thank you.
Thank you.
Appreciate the board's time.
You all ready to go right there? We're just doing some bookkeeping. I'll call the next and final matter of the evening. It's 36-19Z. Jersey 34 Associates, located in the R20 zone, 593 New Jersey State Highway 34. Construct a second building of 22,353 square foot, which would include 3 basketball courts, a locker room, bathrooms, and expansion of parking. We're here this evening for preliminary and final major site plan with C&D
I'm
variance.
happy about this.
Oliver Pape Firm, Peter Clauser representing the applicant. Sir?
I don't play basketball.
Good evening, Mr. Chairman, members of the board, your professional staff, and members of the public. This evening, I do have the pleasure of representing Jersey 34 Associates and the Klatsky family with regard to this application. This property relates to the existing Jersey 34 tennis building that's on Route 34. It's a business that's been in town for some 40 years. It was approved in the late 70s. This is an application about an opportunity to revitalize and reinvest in this longstanding existing business and piece of property and build a second building to the rear to add an addition to this recreation center. The building primarily is designed to house 3 basketball courts. You'll hear some testimony that it'll be available for some other lesser recreation uses. The existing building is proposed to stay the same with the tennis courts. In addition to some of the proposed recreation uses, during this process, we met with Tom Garrity, your fire official for this area, and he asked if we could make that back building, which will be ADA compliant, available as an emergency shelter for the Madison building that's right next door, which we agreed to. So that's also part of the use that's proposed. And you'll see on the plans that there's some emergency access ways that were created with Tom's help. I don't think he's here tonight, but I can represent to you that I was in his offices and we worked with him. So part of the reinvestment into this property includes modernizing a property that was developed a number of years ago. The opportunity to create an updated and rebuilt parking system, on-site circulation, modern stormwater management for the site, for our neighbors, modern lighting for the site, and then updated and refreshed landscaping, which we will present to you. We've worked with your professionals with regard to the landscaping. The landscaping is important on the site and what the applicant is proposing. One of the variances that you're going to hear this evening that the applicant requires deals with your landscaped area ratio ordinance. This site is in an R20 zone, and so the use was not permitted, I think according to Vina's report, when it was originally approved, and it's not permitted now. So we're here for an expansion of that. But we front on 34, and we face Route 34, State Highway, and it's an existing developed commercial property. So the applicant has taken, although we're deficient on landscaped area ratio, the applicant has taken that green space, the landscaping that's proposed, and sheltered it around the rear of the development, where we meet with our residential neighbor and respected your ordinance with regard to the buffer requirement to residential neighbors. So thought was given to the development of the site to direct these new parking areas, lighting, stormwater management, garbage collection, out to the front of the site, which faces Route 34. The use you're going to hear from the applicant provides a service to residents in the community. Right now, they're utilizing the facility for tennis. This will open up an opportunity for families with multiple sport users to be able to use the site all as one, and also to service your existing teams and kids that play in town. So you're going to hear about that. I have this evening a number of witnesses to make the presentation to the board. I plan on starting with Mike Marinelli. He's from Menlo Engineering. He's the design engineer, and he's going to take you through the site and the proposed improvements. Next, we're going to bring up our second Mike of the evening, which is Mike Klatsky. He's a part of the Klatsky family and an owner of the building, and he's also responsible for running this site. And they have other sites, and they have some great deal of experience with regard to this. Then we have Andy Trocchia is the architect responsible for the building. He'll describe for you the building and the internal floor plan. Frank Miskovich is the traffic expert. We're on a state highway. We're working with the DOT. An application has been filed. So we have Frank here. And then, of course, we have Allison Coffin as our planner to complete the testimony with regard to the variances that are required and the basis for those variances. So if I could, Mr. Chair, I'd like to start with Mike, have him sworn, place his credentials on the record.
Sure. Mr. Marinelli, please raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please state your name, spelling your last name, professional affiliation for the record.
Sure. Michael Marinelli, Marinelli, of Menlo Engineering, 261 Cleveland Avenue, Highland Park, New Jersey. I am a graduate of Rutgers University, class of 1999. I've been practicing land use and civil engineering since then, so a little bit over 20 years. I'm a licensed professional in the state of New Jersey. I have been since 2012.
We'll accept his credentials.
Thank you,
sir.
Mr. Chair. Mike, if you can start, we have, this is directly from your plan sheet, is that correct?
That's correct. It's sheet 2 of the plan set. It's just the existing conditions, so I could walk the board through, the survey of the existing structure and the surrounding areas. The lot is designated as block 3236.24, lot 25.02 on the tax map of the Township of Old Bridge. The property is commonly known as 593 Route 34, which is an irregularly shaped lot. You can see there's limited frontage on Route 34, which runs left to right along the bottom of the sheet. It then has a narrow access way towards a larger area where a majority of the development in the existing condition resides. Overall, the property is approximately 4.69 acres and is located entirely within the R20 residential zone within the zoning ordinance. Immediately to the east or the right of this plan is the Madison Nursing Home, that's Madison Center. To the rear or north of the site are residences in the R20 zone. Immediately to the west or the left side of the page is a Matawan Creek, or a tributary to the Matawan Creek, and on the other side, further west of the creek, is the multifamily development there. Along Route 34 to the south is a variety of different commercial uses. All across the way are in the R5 zone. This is on the, I guess, western or southwestern most extent of the township. Matawan is not that far down as you proceed further east. The site in its current condition is an existing rec center. It's 39,160 square feet, and it houses 6 tennis courts that they use for both training, and you'll hear from the applicant or an operator with more detail. This building, as far as I know, it was constructed in the late 70s, has been owned and operated by the applicant since the early 90s. The site is also developed with a parking lot. Again, is accessed, it's a full movement access drive off of Route 34 that comes to the southeast corner of the structure and then across the entire frontage. In that parking lot are 50 parking spaces. 3 of those spaces are actually utilized by an adjacent. Now, if you look in the southwest corner, which also has frontage on Route 34, is a chiropractic center, a doctor's office there that shares access with this particular site. They have some parking on their site, but there are 3 spaces that reside on the subject property as well. Those are all contained within access easements and parking easements in the existing condition. I'll now refer to what I'll mark as Exhibit A1. This is a rendered site plan entitled Overall Plan Exhibit, dated 3/5/2020. This is a rendered exhibit of the submitted site plans with an aerial background to give you a better idea of the surrounding areas, with the landscape turned on as well. So you can see the buffering and whatnot that is being provided. The applicant, that is the correct one, yes. The applicant is proposing so the larger grayish structure in the center of the exhibit is the existing structure that I spoke of, the 6 tennis courts within this rec center. The darker gray area of the parking is the existing pavement on site. You can see it comes up the driveway from Route 34 on the south side of the property, and then there's existing parking along the frontage. The applicant is proposing to add another recreation facility on this site on the north or rear side of the property. That is designated on this exhibit by the brownish color. The building itself is 39,160 square, I'm sorry, that's the existing. The proposed building is 22,353 square feet. Within that structure, there's ample room for 3 basketball courts, in essence. And you'll hear more from the architect as far as the floor plan. But what's planned for the inside of this building is 3 basketball courts. You see, we've also taken this opportunity to improve site circulation. What was once a long dead-end parking area now has a full circulation along the front or southern side of the property. We've also provided on the eastern side additional parking spaces that will be utilized by this new structure to the rear, as well as a drop-off area. You'll hear testimony in a little bit from the operator that a lot of their business is practices and clinics and things where parents are just dropping kids off and coming and picking them up at a later time. However, we have provided ample parking for when they do have games or training or things that may necessitate additional parking. We've also proposed to improve the site from an ADA perspective, providing additional accessible spaces at both the existing structure and the proposed structure, as well as sidewalk connections from those spaces to the front door. Trash enclosures. We're proposing to provide 2 enclosures, one at the end of the drive aisle, all the way to the west or along that property line. And in this particular exhibit, you'll note that the trash enclosure was to be on the northeast corner of the property at the end of the long, at the end of the dead-end parking area. You'll see in a moment, we've actually worked with your professionals a little bit and taken some comments, and we've relocated that, being cognizant that that rear of the property is where the existing residents are, and to try to alleviate some of that nuisance. You'll also note that there's an emergency access noted on the right side or the eastern side, closest to the building of the Madison that is closest to us. We proposed an emergency access. That was for fire egress, and as was stated earlier, there's an agreement in place with the Madison to be able to utilize this facility as a place of shelter. Should anything happen in the nursing facility, they would be able to relocate, and this access way would allow them that access to this site.
Let's just stop there for a second, Mike. The access that you're describing, that's just above the basin, sort of in the middle of that eastern property line there. The access came to us via Tom saying, I need a way to get people from Madison onto your site and back into the rear building. That's ADA. So it wasn't necessarily for, I just wanted to clarify, it wasn't for fire egress for us. It was from him, hey, is there a way that we can get people on site?
So in other words, it was for the need of possible evacuation of the Madison, and these residents could then temporarily shelter in the new proposed facility.
So our agreement, to the extent that Mike mentioned an agreement, is with Tom that we would provide this. Tom, in speaking with him, I said, well, what do we do with Madison? He said, give me a plan and I'll work with Madison. So when you're going to see, I wanted to do this because I want to show you where we started and then how we evolved a little bit in working with your professionals. You're going to see an additional access, and we'll go through how that worked with Tom. But I think it's a significant portion of the site. I mean, in addition to that, he asked for a couple of fire hydrants on the property, which I think Mike can address that, we're putting on the property. So it's important. It's a place next door that he said he's told me he's looked for years to make him feel better about a place to evacuate. And the current building can't serve that because you got to step up into it, and you can't get wheelchairs and things like that into it. But the new building can.
Talking about Tom Garrity or Tom?
Tom Garrity.
Hart?
Yeah.
Okay,
yeah.
just so we can specify.
Yes, yeah. I'm sorry, Tom Garrity. I know he was here last time, but we had to carry it. But I'm real comfortable with what I'm saying. I know I sat down with him. He's very, very happy with us. So I interrupted you. I just wanted to clarify the access. I think we were talking about the parking on the turnaround on the right side of the building.
Yeah, so in total, some of the other site improvements we've provided as part of this application are a total of 120 9 by 18 parking spaces to service this site. 3 of those spaces would again be designated to the adjacent property that shares access to keep the number of parking spaces that facility has a constant. As you can see, we've proposed a significant landscape around, or new landscape around the site. In total, 40 shade trees, 21 ornamental trees, 23 evergreen trees, large evergreen trees planted at 9 to 10 feet along the rear and northern side of the property on the residential side, 145 shrubs or low-lying shrubs, and over 500 ground plantings. So a significant landscape has been used to beautify the site in the proposed condition. We've also provided safe and adequate lighting that meets the township standards. In all, there's 5 LED wall-mounted fixtures at 18 feet elevation, which meets your ordinance requirement. Those building-mounted lights, however, are only on the front facade of the existing structure and in between the two buildings. There are no floodlights or major lighting, high-mounted lighting fixtures on the rear of this particular structure. We're also proposing 12 pole-mounted fixtures. Now, all of these fixtures are downcasting LED, high-efficiency, dark sky compliant type fixtures, as you'll see in the submitted site plan. In all, we have a 1 foot candle minimum and a 2.5 foot candle average throughout the parking areas. There were some comments within the engineering and planning letters to supplement some lighting in certain intersections and whatnot. Of course, we would agree to comply with any of that as a condition of the approval. With respect to the stormwater management, the lighter green area in the lower right corner, the southeast corner, is the proposed detention basin. Now, in the existing condition, the entire site drains from planned northeast towards the west and southwest, ultimately ending up in the creek. There is an existing collection system on site, but there is no detention basin for the existing pavement that is on this subject site. We're proposing to improve the site by collecting the runoff and putting it into a detention basin or extended detention basin. We're also maintaining the existing drainage patterns. Everything will continue to drain in that direction, but in a lot of cases, we're collecting that runoff and conveying it in a safe manner. We're also proposing an infiltration trench. We did some soil testing on site and found, like in a lot of Old Bridge, the soils are very poor. There was one test, however, that had marginal soils for potential infiltration. So we've taken this opportunity to collect the roof or clean runoff and put them through an infiltration system with an overflow so that we can infiltrate some of the clean stormwater should the ground want to receive it. Additionally, we've provided, in order to meet the water quality requirements of the DEP, to backtrack a little bit, obviously because of the added impervious coverage, as well as the limits of disturbance, we trigger the rule from the DEP stormwater management rule, and are considered a major development. So there are thresholds. We've retained or detained stormwater runoff and made the required reductions. We've looked at infiltration and groundwater recharge and are providing methods by which that can happen. And water quality is the other bullet point. We're proposing a water quality treatment device that treats for 80%, which meets the guidelines. So the stormwater management has been designed in accordance with the BMP manual and the NJDEP's requirements or stormwater management rule.
So not only from a stormwater management perspective are you handling the new that we're creating on the site, but you're actually making some improvements to what's being handled on the existing that's out at the site.
We are. So as I said, the site generally grades from the north to southwest, and there are areas or pockets where this water that's coming from the adjacent properties and residents specifically from the north, and conveying that through drainage swales that go down into the ravine. Now, what I didn't mention is when you get approximately 30 feet beyond the existing structure, the topography of the site drops off pretty significantly down into the creek. In fact, there's a steep slope requirement within the board's ordinance. That is shown actually, if you can go back to the first, or if you refer back to the existing conditions, you'll see where that line is. But because the water coming down the back of that and draining towards that, there are erosive conditions that exist in the existing conditions. So we're taking this opportunity also to collect some of that runoff and convey it through pipes and outfalls down to the existing stream in a more safe manner.
Want to move on to the sign? Is that where you want to go?
Yeah,
next?
so, and lastly, we're proposing to replace the existing sign on site. And if I could refer to Exhibit A3, which is, I guess, the third exhibit in your packet. You can see the existing sign and where it resides as it relates to Route 34. So Route 34 in the picture on the left is the roadway you see on the right side of that picture. This is the existing sign, Jersey 34 Tennis Club and Pro Shop. What the applicant had proposed to do, and in the submitted site plans, was to replace that sign, but use the top half of the existing sign with the nomenclature, the Jersey 34 Rec Center, and replace the bottom half with an LED structure, a variable message. And the purpose of that sign is, if you look in the lower right, is they often have a temporary sign there that advertises for certain clinics or tournaments or different amenities that they're having, or during the holidays or camps or whatnot. So that variable message portion of the sign would be utilized to tell the public what those different clinics and things that they may have on a rotating basis. It was recommended from your professionals that we eliminate the pylon sign and make it look more like a ground structure. Unfortunately, as you can see in this picture, immediately behind this sign is the fence and shrubbery that's on the adjacent property. All of that fence and shrubbery is part of the Madison's property. So there's a reason why the sign needs to be elevated. You'll see in the sketch that we provided on the right-hand side a revised detail of the proposed sign. Again, that it would be Jersey 34, tennis and basketball, some variation of that. The digital variable message sign. And then the remainder of the structure would be something that would be ornate. It would be similar to, if you look at your professionals report, they have several examples of signs that they like in the area where there was stone features and capstones and whatnot. So the applicant would agree to do something to make it more ornate and then landscape it beautifully around it to make so that it wouldn't be an eyesore.
So I think the goal when we initially designed the sign was to say we have a sign in place. It's been there. Its location and relative to Route 34 is there. It's where it's visible. We're just going to replace that sign right where it was. And we thought that would be the least intrusive variance relief that we would be asking. The sign is non-conforming, and so we're going to keep the same non-conformities. But when we met with Vina and Nicole, I said, and I'm a big fan of pylon signs, can we do a monument sign? And sure, that would mean moving the sign and getting out of the comfort zone where I can say I'm just replacing what's there, but we felt comfortable that we could support that. Of course, then we go out to the site, and there's a chain link fence that if we drop the sign down, it blocks the entire sign. So we tasked Menlo with the obligation of creating something that's an attractive monument-looking sign, but still gives us the height so that we can get up to the visibility. So that's how we arrived at the sign that's presented. We want to move on to some of the modifications that we made during this process to your rendering.
Yeah, so what I had marked as Exhibit A2 is a second sheet in your packet. Again, after having met with and conversed with Mr. Garrity, as well as your professionals, we took some of them notes and implemented them into this exhibit. The board has not seen this revised layout and/or geometry before. So I'll walk you through the changes. And I alluded to a couple of them earlier. The first being the dumpster enclosure. Instead of the dumpster enclosure being adjacent to the residence on the north, we've moved it to the island where the basin resides. This will allow proper access to it and move it away from that nuisance, away from the existing residences to the rear. You'll also note that there's another emergency egress to the Madison. This was a request by Mr. Garrity so that if a fire truck were to have to get to the back building, they wouldn't be locked into that parking lot. They'd have a way to, this one is an egress for fire vehicles and fire trucks. We have provided it at 18-foot wide and shown Mr. Garrity that the fire truck movement plan, specifically the Old Bridge fire truck, will operate and maneuver in that egress.
We have an email, which I can forward to Kim to make sure that she has it. I don't know if Mr. Garrity copied Kim on it, but he looked at this revised plan and said, looks good to me, approved. And I have that email, and I can forward it to Kim. So the turning templates, the width of it, the location was approved by him.
And probably the biggest change, even though it's pretty subtle from Exhibit A1 to A2, is the landscape in the rear. We had met with your professionals, and they just felt that there was more we could do on the residential side of this property. So you'll note that we now have a staggered row of evergreens, which once was a long row of, single row of evergreens. We've now supplemented that with additional low shrubs and additional supplemental plantings that'll break that up. So it won't be just a single line of columnar evergreens. It'll be a broken up line with additional landscape, including shrubs throughout that area.
So that's what we tried to, I wanted to present to the board the two different exhibits, a little bit of where we were and where we got to after the help from your professionals. And I think the landscaping in the back, and staggering it and supplementing it, who cares what I think? The landscaping in the back, staggering and supplementing, it was an attempt.
We care.
Well, it was an attempt to get your professionals to be more satisfied with that. We also understand, we'll continue to work with them with regard to the landscaping as the site is developed out. We also have, we'll get into it a little bit, but we also have Mr. Lavallo's report, and we know that we can work with him with regard to species and location and safety measures and things of that nature. So that's sort of the purpose of that revised exhibit. What I'd like to do is I'd like to keep going with Mike's testimony, utilizing the report that was prepared by Vina and Nicole to address some of the issues that were raised in there, and I think it'll also provide the board with some more information about the proposed development. This is the planning and engineering report that was dated February 27th, 2020. And I'm going to jump ahead a little bit. The beginning few pages of the report are narrative and provide facts, which we don't need to go over. And I'd like to get into the planning comments and start on page 5. And I just want to walk Mike through some of the issues that were raised and then provide you with our answers and responses. And in that, there's a couple of waivers in here that we're going to ask for. And I'll have Mike take you through that testimony. As far as the first couple of comments with regard to the use variance and the explanation of the proposed use, that is to come. Allison will talk about the use variance, and Mike Klatsky will talk about the actual purposes of this and the on-site uses. Item 1C under the general comments, we talked about the access to Madison Central, and that's what's encompassed inside of that. What's also added into that comment is that there were 3 shared parking spaces pursuant to an access and parking easement with Dr. Peltzman, who is the chiropractic office there. That shared access easement was provided to your professionals. They asked for a copy of it. We sent it in to them. It will be modified to account for the new parking lot. Of course, his access will remain, and the 3 spaces will be identified on the plan. I can tell you that as you look, when you come out of his driveway, that's kind of in a lighter area, the little blur area of the plan, and move to the right. It's the first 3 spaces right there, and they'll be designated with a sign.
His parking area is, the existing parking area is here. These 3 spaces immediately adjacent to that would be the ones designated for his use.
And those will be incorporated into the site plan and an amendment to the existing easement, which has been recorded. It was actually done by Ken Pape while I was in high school, I think. I think it was.
Not far off, because I'll tell. I actually played tennis in this facility in the late 1970s, I think,
so there you go.
early 80s. So,
right,
and Ken was probably just admitted to practice law around then.
No, the easement was later. The easement was
He was
later.
late 70s.
I request,
Yeah.
if you're that old, then just try and stay awake for the rest of the presentation.
I was early 80s. He was late 70s. So.
A couple of, the next one's an easy comment. We were asked to put the dimensions of the basketball courts on the architectural plans. Andy will show you that later, but we did do that. The trash enclosure, we were asked if we could move it, and it was fortunate. We certainly could, and it worked well because it helped us provide the additional access in the rear. There was a request with regard to the rear of the building. Maybe you could show that. There's 2 emergency exits on the rear. Yeah, no, you're great, Kim, thank you. Vina asked if we could put another exit further to the west.
So there are 2 in the submitted documents for the floor plan, emergency egress. However, the one central to the building can be relocated further to the west to alleviate that concern of the plan.
So that's the idea, is just to get that one a little further down. All of the emergency exits comply with, the load and the fire codes and the numbers that we should have. It's just that if we put in more exits, ADA requirements are triggered, and it becomes more pavement and more sidewalks and more activity to the rear, when we could simply just move the one door a little further down.
Did I miss something? Because I think it says adding another.
She had asked if we could add. Our response is, rather than add, instead of having those two
Okay.
close together, move it further down, because Bina can speak for herself, but I think the concern was to make sure that if there's somebody in that corner of the building, they could get to an
I'm
exit
just
quicker.
reading what was here, that's all following.
But yeah, the idea is not to add, but just to move that one down. We move on to the parking. We just talked about the 3 spaces that would be for the owner, for the adjacent owner. There's a request to add bollards and planters in front of the handicap accessible. Mike, is there any
Yes,
issue
we
with that
could-
on the
no,
plan?
we could comply with that.
The LDO, they point out in your land development ordinance that based on this use, we would require 36 spaces. The applicant is parked. They're proposing 120 parking spaces. Frank Miskovich will address our thoughts behind the additional parking spaces. And then, Mike, the next item speaks to
Sure, item
a waiver for
2D on
the
page-
sizes.
Right, 2D on page 6 is related to the parking stall sizes. Ordinance requires 10 by 20 foot parking spaces. We're providing 9 by 18, which is a standard parking size. This isn't a, shopping center where they have carts or anything you have to worry about. A normal commercial use where you have those extra amenities that you need to plan for. So we're seeking relief to provide 18-foot parking spaces where 20 are required.
That's a waiver that we're asking for as part of this application.
Because if you don't, you won't get to the amount?
But it would reduce the number of.
We reduce the number of parking spaces on site, and you'll hear testimony.
I know
as
it'll
to why.
reduce, will you make it?
Well, we
they
do.
quote.
We're
In excess.
we're well in excess of
We
your
don't have a
ordinance
parking
standard.
Could you make it at 10 by 20? Or, yeah.
We could meet the 36, Mr. Chairman, at the 10 by 20, but if you, let us go a little further in the presentation
Go ahead.
as to why we think we need the more parking spaces, and then we can
Okay.
come to a conclusion. But I just want to identify
Okay.
the waiver. The next item is the buffer requirement. The ordinance has a 50-foot buffer requirement when there's a commercial that abuts to a residential. And perhaps, Mike, if you would point out where that buffer is located.
So this is along the rear of the property. It's actually highlighted in dark green. Those are existing trees that are to remain. That buffer is required to be 50 feet. The proposed structure is at 59.7 feet. So we're almost 10 foot in excess of the required buffering in that location. As I stated, there is a lot of existing deciduous trees there, and now we're supplementing that with evergreen trees and shrubs, as I testified to earlier.
There's a request about a sidewalk along the front of the existing building to be installed.
Yeah, so if you look at the exhibit, there's several structures. These are actually HVAC units that extend off the front of the existing structure. So it makes it difficult to provide a continuous sidewalk along there because of these existing structures that are to remain. So we've provided sidewalk where we can, specifically along the accessible spaces immediately in the front of the existing structure.
And then with regard to that sidewalk that we are providing, then the next comment was if the sidewalk can be widened and turnaround areas created.
Yeah, so in the northeast corner of the proposed structure, there's a segment of sidewalk where we proposed it at 4 feet. Your professionals have requested us to increase that segment to 5, and we agree to comply.
Then with regard to the crosswalks on the internal parking areas, we're asking that we not be required to do that in order to maintain the parking that's proposed.
That's correct. And, this is, in this type of facility where you have people coming to practice regularly, everybody knows what the traffic movements are on site, and they're able to get through a parking lot similar to any commercial site without the use of crosswalks. In fact, in my experience, you put a crosswalk immediately in front of the door, but nobody ever walks down 15 spaces to the crosswalk and across. Everybody crosses at the easiest way to get to the front door, right? So in my experience, you can even stripe a crosswalk, but people don't necessarily use it.
Now, there is a critical slope buffer that is on the west portion of the property, and a portion of the building is proposed to be within the buffer, not in the critical slope area, but within the buffer, and there's also a portion of the existing building that's in the buffer. Is that correct?
That's correct. So that line, that buffer to the critical slope, is actually shown on all three exhibits that you have in front of you, so you can refer to any of them. It's basically a half moon on the top left corner of the existing structure, and is again a half moon on the westernmost portion of the proposed structure. The proposed structure is proposed 24.3 feet away from the top of the critical slope area. So the building isn't within the critical slope, it's within the buffer to that slope. In this area, there is no access and/or activity. So there, from a safety standpoint, people aren't directed or will be near the critical slope. So I think the intent of that, the buffer setback is being met. Additionally, we'll note later in the review letter that your professionals have requested that we put up a fence to designate the conservation area that exists on the western side. That fence, of course, would again limit access to the steep slopes and the ravine that is immediately west of this proposed site,
So-
proposed building.
To that end, in the comments, the professionals point out that the board can grant the relief to have it in a buffer, provided that the structure can be constructed safely and that the environmental area is preserved in some manner. So a combination of your statement that we are away from a slope and you're comfortable it can be built on a flat and safe area, and then in addition to that, in accordance with a comment that's later in the report, we're going to put up the signage that's been requested by Nicole with regard to the environmentally sensitive areas, leave it alone, no activity in this area.
That's accurate. And as I provided in testimony earlier related to drainage, we're collecting a lot of the runoff that is in that area to protect those existing critical slopes by not having runoff run down the hill, but be collected and conveyed down to the stream in a safe manner.
And then if one was to look at the plan where we indicated that there's no access to that area, there's a doorway shown, but that's an emergency access doorway only, correct?
That is correct.
And the next comment in the report asks that the site triangle.
You know what's
Yeah,
up?
oh, I'm sorry.
You want to jump in on that, Nicole, now, or can you wait? Well, if you feel like you want to do it right now while it's fresh. Yep.
Yeah.
I mean, I wanted to hear testimony that that the building would be constructed in a safe manner, even though it's, I mean, I think it was like cutting right through the corner of the building. So I think structurally, I wanted to hear some testimony that, the building in the back would, because of that, because of its vicinity to the critical slope. I appreciate that they're I had asked for some sort of fencing along the buffer line, so that people are aware that this is an environmentally sensitive area. That's something typically I do in a residential setting more than a commercial setting. But I thought it was important because, now that there's an increased amount of people coming to the site, I said, let's just keep it consistent. But I'd like to hear testimony that the structural components of that proposed building, that buffer cuts through it. So that upper left-hand corner or the
Northwest corner.
westerly corner comes within that buffer area. So, is there an ability to shorten the building and stay out of that buffer area?
I think the relief is sought on the grounds that the comment included the fact that the board can allow for the buffer to be encroached upon, provided that I believe two factors are satisfied. One, that the building can be constructed safely, which I think Mr. Marinelli stated, and if there's maybe additional drawings or something that Nicole would want to say, I know that we can provide that. We don't want to build a building that's not going to be built safely.
And
we
I
also
think
have the architect here.
don't we generally require some type of an opinion letter from the engineer on that issue?
Usually, I mean, I don't know if that comes later on when we're in the building permit phase, but certainly there could be a note on the plan that states something to that effect.
Yeah, that's certainly doable. And then the second half is to, preserve the area, and we want to preserve the area by following Nicole's recommendations with regard to the signage and also not directing any activity over there. The only activity is internal inside the building.
Okay, we can go back to,
Thank you. The next comment was with regard to the site triangle that can be shown on the plans, and I think that might have actually been added to the plans already. The next is the sign. We discussed the sign. There is variance relief associated with the height of the sign and the area of the sign, which match with the existing conditions, and also the LED portion of the sign. Ms. Coffin will certainly address the variance relief as well as the variance relief necessary for the wall-mounted sign on the rear building. Though your applicant would commit with regard to the LED portion of the sign, this is for only things occurring on-site, the club. There's no off-site advertising of any form that's proposed. The site would not be blinking, and it's not proposed to change on any sort of a regular basis. It's something that might be up for a month at a time or a week at a time. Maybe a day at a time if there's something that transitions. But the idea is that different times of the year, youth basketball starting in the fall, sign up and register, and then that would be up for a while. That's the way that it was, the idea of the LED sign. So not to run afoul of your ordinance that prohibits the flashing, blinking, scrolling. All of those can certainly be conditions of the approval.
Right.
That would not be proposed. There is a comment from in the report that there is 2 signs located in some vicinity to each other. The second sign is off of the property. It's for the chiropractic use. We don't seek to combine the signs. Number one, whoever comes onto the other person's property then creates a new D variance for off-site advertising. Don't really want to create that additional variance. And so they're 2 separate entities, 2 separate properties.
If I may,
yeah.
to be clear, the sign, and we're talking about figure 3 on sheet 8 of the report, the left sign for the chiropractor that, again, shares access with us, that sign is on private property. That's on his lot. We have no control over that sign as well.
We'd like to just leave the signs the way that they were. The last comment on that page deals with the wall sign, which is proposed, and Allison will speak to the relief that's required for that. With regard to lighting, you indicated that you can comply with the lighting plan. Some of these get a little easier.
Yes.
We have no issue with the comments with regard to lighting. The lighting that's mentioned with regard to the emergency exits in the rear of the building, we're conscious of our residential neighbors behind us, and Mr. Trocchia can speak to the emergency-only lighting that'll be out there just to meet the necessary building codes. Landscaping, I mentioned earlier of the landscaped area ratio, which is in comment A, and that's variance relief that Ms. Coffin will address in her testimony. The next comment references the Old Bridge Township tree ordinance will comply with your tree replacement ordinance. We're trying to do substantial landscaping on site. There's in Mr. Luala's report, I'm not going to go to his report specifically, but there were a couple of heritage trees that were pointed out, and there's one that you can save that's on site in the area of the basin. Is that correct?
That's correct. So we sent to one of our landscape architects out to kind of investigate what was found in Mr. Willow's letter. And there's a significant tree that resides on the east side of the property along the detention basin. Now, we were proposing to build a retaining wall 10 feet from this significant tree. However, the construction of that wall would have a negative impact, obviously, on that tree, supposing that it is a heritage tree. So we've actually done some calculations and found that we can modify the basin shape slightly and build a wall that's much further away from that tree and save it per Mr. Lavello's recommendation.
Confident we can work with his report and like I said, meet his requirements.
give him a quick minute, as long as he's here, because
Sure.
we don't want to run short on time. Mr. Lavallo, any comment, or you happy with their commentary that they'll comply with all the ordinance?
Yeah, I believe so. The heritage tree on that right side was the most significant one. The ones in the back are not so significant, and that's the reason why we focused on that one.
So they're agreeing that they'll comply with
As long
everything.
as it's far enough away, I don't know what the measurements are or what the distance is, but when they submit that to me, I'll review it at that time.
Thank you. Continue.
Thanks. The next two comments, C and D, deal with landscaping, and I think that they're addressed in your overall enhanced landscaping plan. We could certainly find the opinion of your professionals as to whether they like what we've done or not, and we're willing, as always, to continue to work with them to make the best landscaping plan that's possible. The next two comments, one is not applicable, and we comply with the landscaping strips that are identified. Mike, the comment G on page 10 deals with some gross parking area landscaping, and we've indicated that we comply, and it was asked for some explanation as to why we think that's the
Sure,
case.
so the ordinance requires 20% of the gross parking area to be calculated as landscape. Based on our calculations, the parking perimeter is what my landscape architects like to call it, is the strip of land that surrounds all of the parking. And based on that calculation, we do meet the 20% requirement. But we'll agree to work with your planner to justify those calculations, and if not, make any modifications that are required.
The next comment H deals, if you could speak to the landscaped islands and that we're asking for relief from that requirement.
Again, we spoke to this a little bit earlier with respect to losing parking spaces. You're going to hear testimony from both the applicant and traffic expert that talks about what we think we need from a parking perspective. What the ordinance requires is that only 10 parking spaces be in a row. We have in several locations on the site where it's in excess of 20 parking spaces in a row in order to get to the 100.